I know that our charge for today is to debate the importance, utility, and constitutional imperative of jury trials in patent cases. And as the opening speaker for this forum, I probably then should just lay out some factors for you to consider and then leave it to all of you, the academics and the trial judges and the advocates, to express firm views on the topic. But anybody who knows me well knows that you're unlikely to see that kind of restraint from me. The importance of maintaining the integrity of and proper respect for juries in our system of justice, even in patent cases, is too fundamental a topic about which to remain neutral. I'm an unabashed believer in the jury system, an unabashed believer that juries can and do take seriously their obligations as jurors, an unabashed believer that juries can sort out even the most complex issues when given the proper tools, and an unabashed believer that juries almost always arrive at conclusions which are rational, fair, and even if not the conclusion I would reach in every circumstance, justified by the evidence presented and the legal principles they were charged to follow. As the Supreme Court said in Beacon Theaters, maintenance of the jury as a fact-finding body is of such importance and occupies so firm a place in our history and jurisprudence that any seeming curtailment of the right to a jury trial should be scrutinized with the utmost care. Respect for these fundamental principles is built into the rules of civil procedure and those jurisprudential principles that define and delimit the appellate function. Rule 50 of the Federal Rules of Civil Procedure only permits a court to displace a jury verdict where the court concludes that a reasonable jury could not have a legally sufficient evidentiary basis to reach the conclusion it did. Just as the Supreme Court declared in Teva that there's no patent law exception to the mandate of Rule 52A, which demands appellate deference to fact findings by a district judge, there must be no patent law exception to the mandate of Rule 50A either. While not spelled out by rule, moreover, there are basic principles relating to the appellate function whose purpose is to demand proper respect for district court proceedings, and particularly the role of the fact finders in those proceedings. Thus, appellate courts may not consider evidence not included in the record below, may not address an issue raised for the first time on appeal, may not make credibility determinations, and may not reweigh the facts underlying express or implied factual determinations made in the trial court. All of these restrictions on the appellate function, backed by years of common law precedent, are predicated on the importance of respecting the trial court's role in the judicial process, and particularly the role of the jury as fact finder. Trial court judges must respect their Article III role by adhering to binding precedent even when experience has proven it to be unwise, unworkable, or outdated. Appellate courts must respect the importance of the trial court function in return, giving due deference and respect to the fact-finding function of trial judges and juries. As the Supreme Court has cautioned, duplication of the fact-finding function of trial courts at best would contribute negligibly to the accuracy of fact determinations and would do so at a huge cost to both the parties and the judiciary. Now, despite these basic principles and the long history of respect for the jury function, many, including probably some of you in this room, argue that we should do away with jury trials in patent cases. I've heard a number of arguments in support of that contention, and I want to address some. I don't have time to debunk them all, and I'm hoping that some of you will take up that mantle for me yet today. So I'm only going to focus on two. The claim that juries are incapable of understanding the factual and legal complexities in patent cases, and the contention that the formation and existence of the Federal Circuit indicates a congressional desire to treat patent cases differently and to place their resolution in the hands of a court with expertise in such matters. I reject both of those contentions without hesitation. I'm not going to debate whether there is or should be a complexity exception to the Seventh Amendment. I'm going to leave that to the next group of speakers. I will simply say that I don't see a need for such an exception and explain why. Jurors historically have been called upon to decide complex questions, even those involving detailed scientific inquiry. The Federal Judicial Center and the National Academies of Science have combined efforts and recently revised the Manual on Scientific Evidence. Its length and the breadth of the topic areas it covers reflects the broad range of scientific issues presented in all manner of federal cases, both criminal and civil. In my years on the district bench, I observed jurors receive and be tasked with deliberating matters relating to a diverse categories of complex scientific and financial evidence. In the main, patent cases are simply no more complex than cases involving toxic torts, aviation disasters, securities fraud, Ponzi schemes, antitrust conspiracies, or even criminal matters with multiple defendants, dialects, and forensic data points. After every jury trial over which I presided, I spoke to the jury at length. I wanted to thank the jurors, to answer questions they might have about the process, and importantly, to help educate myself and ultimately the participating lawyers about jury dynamics and their deliberative process. I was always impressed by how thoughtful and careful the jurors were, how objective and logical their analysis was, and by the level of work in which they were willing to engage. In one highly complex case involving multiple experts and a large volume of exhibits, the jury told me that they agreed to spend the first 2 days of their deliberations silently going through every piece of evidence, their own notes, and the jury instructions that I had given them to assure that once an interactive dialogue among them actually began, that it would be a fully informed one. Well, my experience over the almost 200 jury trials over which I presided is only anecdotal. I came away from each trial believing that studies that concluded that larger juries tend to reach better reasons conclusions were likely right. If 2 minds are better than 1, 9 or 12 are exponentially better than only a few. And I came away with the conclusion shared by most district judges around the country that jurors working collectively mostly get it right. I place fault for a less than perfect experience with juries in patent cases, not at the feet of jurors, but at the feet of trial judges, advocates, and our court as well. Trial judges and advocates can improve juror decision-making in patent cases in a number of ways. I'm only going to mention a few. First, early and continued case management by trial courts and willing input and cooperation in that process from counsel can narrow and clarify questions that must be put to the jury. Second, advocates can engage in targeted rather than rambling discovery with an eye toward what they or their opponent will really need to prove once trial arrives. That will cause counsel to narrow their focus early and not be tempted to take jurors down only marginally relevant factual rabbit holes. Once trials do arrive, trial judges can allow jurors to take notes, guard against disjointed or repetitive presentations of proof, require counsel to clarify matters where the possibility of confusion seems obvious, encourage the use of technology in trial presentations. This is critical because jurors retain about less than 50% of what they hear, but they retain about 70% of what they both see and hear. Trial judges can also insist on jury instructions that are written in understandable prose, not legalese. Can ensure that each juror has a copy of those instructions with them in the jury room, and can insist on verdict forms which provide jurors with an understandable decision tree so as to protect against inconsistent or incomprehensible verdicts. As a district judge, I was stunned by the lack of care that went into proposed jury instructions. I came to believe that the people that were actually trying the cases never even looked at them, and they assigned them to some young associate, because there never seemed to be a real correlation between what was going on at trial and what was showing up in the jury instructions. Counsel seemed more concerned with laying out complex legal principles in ways that would confuse even those learned in the patent law than with conveying real needed information to jurors. As an appellate judge, I'm now stunned not only that the practice continues, but that trial judges will often accept such unhelpful offerings without aggressive editing, presumably because they figure that if the parties are going to agree to those stupid instructions, then they're less likely to get reversed based on an improper instruction. Now, finally, while I know some of you are going to debate me on this, maybe even some of the trial judges that have to try cases over and over and over, I believe that trial judges should avoid the use of arbitrary time limits that make it impossible to explain matters adequately to the jury. Don't get me wrong, I think time limits are very important because they have to be used to impose discipline on the process. But what those will be in a given case should depend upon the issues to be decided, the nature of the technology involved, and other case-specific circumstances. I just don't think that jurors can be expected to understand what advocates lack the time to explain. Now, trial advocates can refrain from trying to prove to the jury, the judge, to their clients, or even just to themselves, that they know more about the relevant science than anyone in the room. They can do what litigators who try all manner of cases really do: convey to the jurors just that level of scientific information necessary to their decision making. In my experience, when jurors get confused about science, technology, or accounting, it's often because the advocates create the cause for the confusion. Patent lawyers tend to overthink and overpresent their cases. And I can say that without being criticized, because I was a patent lawyer once, my husband's a patent lawyer, I have a lot of good friends that are patent lawyers, but I still believe that this is true. Patent lawyers need to be tight and succinct in their presentations, use courtroom technology to their advantage, and cross-examine the opposing expert the way they would cross-examine a hostile witness in a car accident case, rather than engage in a high-level debate over scientific theory. And they need to make sure they proffer evidence on every fact or legal element they need to prove or disprove, and make sure it gets admitted over those objections that you know are bound to come. Advocates also need to couch their legal arguments in understandable terms, in ways that walk the jury through the jury instructions and ultimately lead the jury to the desired conclusions on the verdict form. Rather than continue the mantra that patent cases are just too different from other cases to allow them to go to a jury, advocates need to stop treating patent cases as different and use good, solid trial lawyering skills to educate and persuade the juries they encounter. If they do this, well-instructed jurors will likely reach the right result. As then Chief Judge Howard Markey said in 1985 in his opinion in the en banc decision in SRI International, "There's no peculiar cachet which removes technical subject matter from the competency of a jury when competent counsel have carefully marshaled and presented the evidence of that subject matter, and a competent judge has supplied carefully prepared instructions." Now, all of that said about those involved in the trial process, my placement of blame for problems arising in the use of juries in patent cases does not end with the trial judges or trial lawyers, though everyone in this courtroom is accepted from those criticisms. It includes our court as well. And this is something I feel very strongly about. When appellate tribunals show a lack of respect for jury verdicts and fail to give adequate deference to jury factual findings and the implications of those factual findings, the ripple effect is devastating. Trial judges become incentivized to take questions away from juries whenever possible, fearing that the hard work in supervising a jury trial is a vain exercise. Advocates have less incentive to explain things clearly for the jury because they begin to believe that they are playing to a different audience, one who believes it is the first instance fact finder because it somehow has a better ability to grasp or understand the issues at hand. Clients lose respect not just for the jury process, but for the judicial system as a whole, perceiving that it's simply not working the way the civics books say it should. And jurors would have less motivation to get the right result, knowing that what they do may not mean much in the long run if they're always second-guessed on appeal. As Judge Newman said in her dissent in Malta versus Shumeric Carolines, when the relationship between trial and appellate tribunals is distorted, the consequences disserve the public and the courts, impairing the confidence of litigants and the public in decision of trial courts and multiplying appeals. Now, by my count, which I concede was not exhaustive, there are at least 24 petitions for writs of cert that have been filed in the last 10 years, where one of the principal objections to the Federal Circuit decision at issue was our court's supposed failure to recognize the limits of our appellate function and our willingness to usurp the province of the trial court, the jury, or both. Some commentators have actually coined the term judicial hyperactivity to describe our court's alleged penchant for usurping elements of the decision-making process that are supposed to be the province of the lower courts, administrative bodies, or even litigants. Now, I'm sure not all of the criticisms heaped on the Federal Circuit are deserved. But to the extent such improper decision-making is creeping in, or perhaps pouring in from some views, to our judgments, then we too are guilty of weakening the jury function and causing dysfunction within it. Now, in this same vein, our court's stingy view of what renders a district court judgment predicated on a jury's verdict final further displaces the crucial role of lower courts in patent cases. No other court of appeals has readily dismissed the importance of lower court efforts and judgments by characterizing them as non-final in similar circumstances. I believe that we all should strive to respect the role of juries in all cases, including patent cases. Where inefficiencies are preserved, we also should exercise care in where we place the blame and on what fixes we propose. All participants in the process can do more to improve the quality of jury verdicts. In my view, neither the jurors themselves nor the jury system that has characterized our judicial process for so long are the problem. Now, I know I have heard things about people saying patent cases are just different and everybody should treat them differently, and Congress even treats them differently. But I don't think anything about the existence or formation of the Federal Circuit alters my view that jury trials are an important aspect of the adversary process in patent cases, or that our court is obligated to treat those cases with the same deference that other circuits must afford verdicts in all cases. As you know, the Federal Circuit was formed in 1982 to address a perceived lack of uniformity in the enforcement of patent rights. The various regional circuits had differing views on patent scope and quality, and the Supreme Court had shown little interest in resolving those differences. The Federal Circuit was formed to limit forum shopping and reduce the inconsistencies among the circuits. Congress felt that a lack of consistency in how the patent law was interpreted and applied endangered innovation by making it difficult to rely predictably on the rights patents covered. Notably, the Federal Circuit was not formed to craft patent policy. Remarks by Senators Baucus and Leahy in the legislative history for the act that created the Federal Circuit are telling. Senator Baucus spoke out against creating a specialized court, arguing that if there's a perceived ambiguity in the patent laws, then the appropriate congressional response should be substantive reform, rather than passing on the issue of a new court. Senator Leahy, on the other hand, responded, supporting the creation of the court to address non-substantive problems with patent law. He said that the court, quote, will not solve any of the substantive problems with our patent laws, but it will go a long way to diminishing the forum shopping and reducing both the excessive costs and inconsistency in patent litigation. So Congress didn't choose to create a quasi-adjudicatory agency when it created the Federal Circuit, nor did it create an Article I court with specialized rules and processes. It created an Article III court governed by the same rules and the same decisional paradigms that govern every other Article III court. And it populated that court with generalist judges, and it created a court with a broad jurisdictional reach. It's not just the patent court. The uniformity Congress hoped the Federal Circuit would bring to the patent system is uniformity born of its traditional adjudicative function and the fact that there would be only one court to which patent appeals could be taken. Congress did not charge the Federal Circuit with deciding whether the patent system should promote innovation or competition or access to low-cost medical supplies or any other goal. It charged the Federal Circuit with applying the law to the cases before it. And Congress did not free the Federal Circuit from the obligation to abide by the Federal Rules of Civil Procedure or those common law principles that govern and guide all courts of appeals. Even the Supreme Court, who's given wide berth to the Patent and Trademark Office to adopt whatever rules and procedures it wishes to, as long as those rules and procedures have the effect of invalidating more bad patents. The Supreme Court has made clear that neither the character of patent law nor the unusual character of the Federal Circuit's jurisdiction frees the Federal Circuit from its Article III mantle. eBay, MedImmune, KSR, Gunn, Teva, Highmark, Halo, to name only a few, are all Supreme Court decisions that contain unmistakable language and straightforward holdings reminding us that the work of the Federal Circuit, even in patent cases, is governed by the same rules of procedure and evidence and the same restrictions on its interpretive function that govern all courts in the federal system. Ultimately, we must all accept the fact that patent cases are just that. Civil cases arising under the patent laws that are to be litigated in the federal system with all of its historical strengths and weaknesses. Now, before I close and take questions, I just want to make one more quick point. I wouldn't be too quick, as I know some commentators have been, to argue that we should resort to jury trials in patent cases merely because other countries do so. While international uniformity in patent laws has some appeal, I don't think we should take that principle too far. Virtually no other country employs jury trials in any civil context, and none afford jury trials the respect that we do. At the risk of waving the flag too fiercely here, we need to remember why the founders felt that the right to a jury trial in both criminal and civil cases should be enshrined in our Bill of Rights. The need to protect individuals from the will of the sovereign, or the whims of the majority who might be responsible for electing that sovereign, is what prompted our carefully crafted Article III system, and the right to a jury trial, which is at its core. That system is what sets us apart from the rest of the world, and I believe it does so in positive ways. Chipping away at that system in any context seems ill-advised, including the context of intellectual property rights, which the founders also felt were important enough to explicitly mention in the Constitution. In the end, as I said, I'm an unabashed believer in the jury system, and I don't think that we should do away with it in patent cases. If anything, we need to strengthen it. Thank you.